What is patent prosecution? When you hear the scary word prosecution, you might imagine yourself on the wrong end of an episode of Law & Order.
You're getting yourself all worked up, detective.
Maybe I'll work you up.
But with patents, the term prosecution shouldn't scare you. In this two-part video, let's learn about what the term patent prosecution really means. In a nutshell, the term patent prosecution refers to the process of obtaining a patent to cover your invention. The process of patent prosecution involves several phases. Typically, you only want to engage in patent prosecution with the help of a good patent attorney. So without further ado, here are the 6 main phases of patent prosecution. First, you want to build an overall IP protection strategy. Often, your IP strategy will involve exploring patent alternatives such as trademarks and copyrights. Trademarks protect the brand identifiers of goods and services, while copyrights protect works of authorship. Outside of trademarks and copyrights, you might want to explore trade secrets as part of your IP strategy. The trade secret strategy involves determining what parts of your invention or what inventions you want to keep secret as opposed to making them public during the course of patent prosecution. A famous example of a trade secret is a formula for Coca-Cola, which has been held secret for nearly 100 years without a patent. But trade secrets generally only work when your invention can't easily be reverse engineered. So patents typically work better when your invention can be looked at and taken apart and rebuilt by someone else. In many cases, patents are a preferable alternative to secrecy because they actually give you the right to exclude others from making, using, or selling your invention.
This is making me think maybe I should slap a patent on my kitten mittens before you guys try and steal that too, huh? I can see it in your eyes. You're all over this, aren't you?
To build an effective patent strategy, you need to think about what your invention is now, how it differs from other inventions in the past. You should also explore what your competitors are doing in the space, and think about where you might take your invention in the future and how you might grow your portfolio. A good patent attorney will incorporate all of those considerations into a patent strategy and help you build a plan to file one or more patent applications to effectively protect your invention. The second big phase of patent prosecution is the process of claiming your invention. Claims are the part of your patent application that define the scope of your invention. Without claims, you own nothing.
I have nothing.
Your patent attorney will help you build a set of claims that broadly protects the scope of your invention, but also anticipates the rejections that you might face from the USPTO during the course of patent prosecution. For instance, your patent attorney might help you devise a fallback strategy to help you prioritize the most important claims associated with your invention in case the USPTO finds other claims associated with your invention unpatentable due to prior art issues or obviousness issues. And patent claims are the most important part of your patent application. You absolutely should have help from a good patent attorney to build your set of patent claims. Patent claims are among the most difficult items of language construction to create in all of law. A poorly drafted set of patent claims can have severe consequences to the validity of your patent. For instance, the misplaced phrase, "the invention is," can dramatically reduce the scope of your issued claims. Moreover, simply switching the words "consisting of" with "comprising" can impact the entire validity of your patent. These are just a few of the ways that a poorly constructed claim set can dramatically impact the value of your patent. The third key phase of patent prosecution is building a patent application specification. In a well-drafted patent application, the spec will incorporate all crucial components of your invention. The spec will include dimensions of every part of your invention, the materials that each of your components are made from, and how all of the components work together to actually enable your invention to work. For your patent to be valid, the spec must teach someone who is skilled in the art associated with your invention to make or use your invention. The spec must also teach the best mode of your invention. So if you're thinking about keeping part of your invention secret so that the world doesn't know how to make the secret sauce, that might lead to your patent being held invalid. These are the first 3 big phases of patent prosecution: Click the link to Part 2 below to learn about the last 3 big phases of patent prosecution.